Okay, good morning, everyone.
Good morning, Your Honor.
Welcome to a session of oral argument, the Fifth District Court of Appeal. My name is Kerry Vander. I'm joined on the panel by Judges Eisnagel and Harris. We are here on case, let's see, 20-1031 Arnold versus Arnold. Each side will have 20 minutes for oral argument. Let me go ahead and mention, since we do have a cross appeal, as far as the appellee, Mr. Simmons, how much time or how much warning do you want to get? Because during your initial argument, because you do have a chance for a rebuttal on the cross appeal.
Yes, Your Honor, 5 minutes.
Okay. And Mr. McGee, how much time do you wish to reserve on your initial argument?
I would like to reserve 7 minutes, Your Honor.
Okay. I'll try to help you in that regard, but there is a clock there to assist you as well. These arguments are being live streamed as well as being recorded, so the public does have a chance to view them. With that, Mr. McGee, you may proceed.
Thank you, Your Honor. May it please the court. I am Patrick McGee. I represent John Arnold Jr., J. Robert Arnold, and JJJR Properties, and we seek a de novo review of the summary judgment disposition of plaintiff's claims to declare void the multiple recorded deeds and the bills of sale that were signed by one of the plaintiffs himself, John R. Arnold, as general partner of Arnold Groves and Ranch. Historically, Arnold Groves and Ranch had two general partners, and they were Dr. Arnold and John R. Arnold, Inc., which was wholly owned and controlled by Dr. Arnold. 4 months before the Arnold Groves and Ranch deeds were signed and recorded in the public records, the corporate general partner was administratively dissolved by the state of Florida, a certificate of distribution.
You can certainly give us the facts if you want, but my guess is the panel's aware of them. And given the number of issues you've raised in your brief, you might want to just jump right into your arguments.
I will, Your Honor. I'd like to start with Judge Munyon's order, the summary judgment order, which was erroneous in multiple respects. First, Judge Munyon observed that the administrative dissolution of the corporate general partner was not an event occasioning dissolution as defined by Section 1 of the partnership agreement, but even if it was, the corporate reinstatement related back to the date of administrative dissolution. And this was faulty and erroneous analysis for a number of reasons. But Judge Munyon also concluded that John R. Arnold, Inc. was knowingly permitted to be administratively dissolved. Related issue. The record in this case is to the contrary. Attorney Stark discovered the administrative dissolution on his own by checking Sunbiz, and it was not part of a plan. That's in the record at 1534, 1545, and 1546, discussed in our brief as well. Judge Munyon also observed that John R. Arnold, Inc. did not sign the plan of dissolution or the conveyances. And Judge Munyon found that if only the minority general partner signed, then it was not effective under paragraph 7(1)(a) of the partnership agreement. And this is wrong. And Judge Munyon's disposition of the affirmative defenses was also legally and factually flawed and erroneous. Now as to the events occasioning dissolution.
Counsel, if we could maybe address one issue that I was struggling with and get that out of the way. In your brief, it seems like you argue that the section that the trial court's reasoning reliance on section 7.1 of the partnership agreement is in error because that was not raised in the motion for summary judgment. Is that one of your arguments?
It's one of them, Your Honor, but
well, counsel, if we could address this one quickly first, if it merits it, I couldn't find where you preserved that in the record. Could you tell me where in the record you raised this argument with the trial court?
Well, we didn't. It was raised sua sponte by Judge Munyon in her order. So
in your motions for reconsideration, I looked and I couldn't find anywhere where you raised this particular problem.
I don't know whether that's the case or not, Your Honor. I honestly don't. But I can jump right into 7.1(a) and the approval issue itself, because even if it was not preserved and the judge did her analysis under 7.1(a), the approval issue is a bit contorted and erroneous in the analysis. 7.1A only requires approval by a majority of the general partners. Now, that's assuming the corporate general partner was still a general partner. And under the Florida law, under 620.124 statute, 607.1421, when the event occasioning dissolution occurred, John R. Arnold Inc. ceased to be a general partner. Even if it was, the approval that's required would be sought from Dr. Arnold on behalf of the corporate general partner. In other words, approval sought from the same person that signed the deeds. Approval is not written. It's not required to be in writing. It is, and it's a very low standard. It's just that Dr. Arnold, the person who signed the deed individually on behalf of the corporate general partner, had a favorable opinion of or thought well of the acts that he was taking. And are
you asking us implicitly to set aside the difference, if you would, between the corporation and the individual, and say for these purposes the individual was the same as the corporation? I mean, can we just assume that if the individual signed something acting in his corporate capacity, he would, or might he view himself as having different duties in that situation?
I doubt that the record would support that, especially in a summary judgment context. Is there an inference here, at least an inference, that Dr. Arnold, who as the individual general partner took a specific course of action and signed specific deeds, approved of going forward in that respect? He signed the deeds. He has told his attorney exactly what he wants to do.
But if we're going to treat corporations as separate entities from individuals, and if, assuming that the deed had to be signed or the plan had to be signed by both, can we just ignore the fact that only one signed it?
Well, but the deed did not need to be signed by both.
I'm not talking about the deed, the plan of dissolution.
Well, the plan of dissolution didn't need to be signed by both either. None of this approval requires a signature of both general partners. Approval under the statute and under the partnership agreement is not a defined term. So we go to either the dictionary definition, or you can look at the Frankenmuth case that we signed or the cited, or the Anderson case that we cited, for what that means, what approval means. Now, consent under the statute is something different, and consent that requires a record would be something different. Our legislature knew the difference. They used the two different terms in the statutes, consent and a record versus approval. Approval is and
So I think the distinction you're making there is not lost on us. I think we understand what your argument is, but I think what Judge Evander's asking is, where is the approval as you define it there? Between, we understand there's the corporate entity and then there's the individual. Where's the approval of both? Or are we to assume that when Arnold signed in the corporate capacity that it was also equally applicable to the individual?
Well, the approval as to the course of action would have started August 31, 2017, and that would have been before the administrative dissolution the following month. And you'll find in the record at 1546, Attorney Stark testifying that he was hired on August 31st by Dr. Arnold. He wanted me to dissolve the limited partnership and find a way to squeeze out these three limited partners. So he, at that point, represented both entities. If we're going to engage in the fiction that Dr. Arnold ceased representing both entities at some point, or was speaking for only one. Mr. Stark testifies that that's what he wanted done. He was completing what he started back in 2015 when he asked me to buy out those limited partners. And then Mr. Stark also testifies in multiple other places that we've cited in our brief about what was to occur. For instance, at 1538, it said all decisions were made by Dr. Arnold in the meetings that we had.
How does 4.2, section 4.2 play into all this? Oh, the partnership agreement.
Oh, 4.2 of the partnership agreement? The one relating to transfers, Your Honor, is that?
Distribution in order of priority.
Oh, I don't think it does.
Okay.
I think the the statutes themselves deal with the distribution or the conveyance of the assets of the corporation, and the even all of the assets of the corporation, not in the ordinary course of business. The challenge here that's raised by many of the defendants is we didn't like the valuation that was attributed, or we wanted distributions.
Well, is it, when you say it doesn't apply, what does that mean? Do you agree that 4.2 was not followed in this case?
I don't think there's record evidence in this case to show that conclusively it was not followed. What are we lacking?
Well, I don't know. I mean, I don't see anything in 4.2 about a mortgage and note.
No, the valuation.
So that would be, I mean, that'd be pretty conclusive, right? There's no mortgage and note in 4.2. It's pay the debts, liabilities, and reserves, and then pay into capital accounts of partners.
Well, there's no evidence that the capital accounts were not unpaid, but maybe more important.
Well, hold on. You gave a note that that some of the partners here received a note in mortgage. That doesn't sound like paying into capital accounts, counsel.
No, I agree with what you're saying there, Your Honor. The issue that was decided by summary judgment below was the validity of the deeds that were executed by the general partner of Arnold Groves and Ranch. So if there's a violation of the partnership agreement as we didn't pay into the capital accounts, that doesn't invalidate as a matter of law the deeds that were signed by the general partner. Those are controlled by the statutes. You can't look at just 4.2 and say if there was a violation of this, those deeds are invalid. What would our public records look like if that were the case? It just simply is not the law. The law regarding conveyances of real property is under 689.045 by limited partnerships, and it's dealt with in Chapter 607, 1406, I believe is the statute about conveyances of property. What must be done under those circumstances? So if the approval process that we're dealing with here is based upon a summary judgment ruling by Judge Munyon that the corporate general partner did not sign the deeds, it's defective for multiple reasons. There's no requirement that both partners sign the deeds, just that a general partner sign the deeds. There's no requirement that approval shall be in writing. And there's evidence of approval throughout the record in this case. We've cited Mr. Stark's testimony in multiple places as to what Dr. Arnold instructed him to do, and that it was done in accordance with his own wishes. And we have Dr. Arnold's testimony as well as to his desire to dissolve the limited partnership, and that's at 377. That Dr. Arnold approved of the transfers, that he was down with that he approved of it. So you have record evidence of approval. You do not have a legal basis for saying that as Judge Munyon did, that only one of the partners signed off on the deeds and conveyances, and that under those circumstances that the deeds and conveyances were invalid. The administrative dissolution as well gave you a further reason, gave the record further reason to show that the corporate general partner was no longer a general partner, ceased to be a general partner during these periods of time. And I see that my time is running low, and I'd like to reserve for rebuttal unless the court has further questions at this time.
All right, thank you. Mr. Simmons.
Yes, good morning, Your Honors. May it please the court. This case arises out of a posturing document, a plan of dissolution that was dated January 18th, 2018. And as Mr. Stark testified, he said that Dr. Arnold wanted to find a way to try and squeeze these three limited partners, which were Kathy, Susan, and Jeffrey, out if they were not working, since they were not working in the partnership What happened is that obviously Dr. Arnold, after these discussions, was concerned and on several occasions tried to not do this, but ultimately the plan of dissolution occurred. Mr. Stark says it was a posturing document to squeeze out 3 limited partners, and the method that they used as a catalyst, as he testified, was an administrative dissolution of John R. Arnold Incorporated. It would have been easy to have gone ahead and just pay the fees to keep it, but it was done. The plan of dissolution falsely states that the value of the partnership assets is $11 million. So we have an appraisal that is a fair market appraisal of $54 million. The plan represents that Dr. Arnold was a sole general partner. That's not true. There were 2 general partners. The defendant appellants admit that. The plan states that the assets of John R. Arnold Incorporated were transferred to Dr. Arnold upon the dissolution, the administrative dissolution. That doesn't occur. That's a legally incorrect statement. The plan states that Dr. Arnold was taking action as the sole general partner. That's not true. He was not. He was not the sole general partner. All of this was kept secret from the 3 sibling limited partners who are, Catherine and Susan and Jeffrey. And they had no knowledge of it until they received a letter that says, come to Mr. Stark's office on March the 20th, and you will receive, or, that the limited partnership is dissolved.
Mr. Simmons, I could ask you a couple questions. First, what is the significance, if any, that the notes that were given to the 3 younger children, 3 limited partners, came from a different entity than Arnold Groves?
It's exceedingly, Your Honor, very important, because the law says that there should be upon a dissolution, if it were valid, a distribution that would be to the partners in accordance with, of course, as set forth in 4.2, distributions upon winding up, and that would be to each of the partners. These non-negotiable 10-year promissory notes were from an entity called JJJR LLC. This was done approximately 2 weeks later than after the dissolution and after the distribution, and that is very important, because it's not the proper way to do a dissolution.
Okay. All right. Thank you.
And so what happened is that these promissory notes were never delivered. They're being held right now by one of the counsel, actually counsel for Mr. Stark, because they never were delivered. The only thing happened on that March 20th meeting was that there were